And now, a video brought to you by Hector Salamanca Cam Clips. No audio. Welcome to the live show. Happy hump day, everybody. Oh, it's almost Good Friday, almost spring break time for me in Jersey. How we all doing? I am your host, Time Served. How we doing? How's everybody? Everybody's trickling in. Let's have some fun. Oh boy, do I have a show for everybody. I have so many clips I compiled. I can't even get to what was sent to me in Discord. I just have so many on my own. So, let's start the show with, oh, I got a goodie. Let's go to Seatac, shall we? Seatac never disappoints.
Prerequisite order be adopted but modified.
Wait for it.
Hungry.
Hi, Miss Nguyen. This is City versus Kelly Nguyen, 3A0252202. And this case is on for arraignment. How are you doing, Miss Nguyen?
It sucks.
Being in jail? Yeah. Is this your first time being in jail?
Is this jail? Why am I in jail?
Did you talk to Mr. Ainati about this, about something that happened yesterday?
That's me, Miss Nguyen.
Okay, what are my charges?
Malicious mischief and resisting arrest.
I didn't resist arrest.
Miss Nguyen, I don't want to talk about the facts, but do you remember talking with me?
I did not.
Did you talk to Mr. Ainati? He's the man in the box with the number 2 on it. Did you talk to him earlier today?
So what is your name is?
Miss Nguyen, do you remember talking to me?
walked up, you asked me.
And Your Honor, I think we just asked to address the conditions of release, and I think we are gonna ask that for evaluated either, depending on what the court does, either in custody or out of custody.
What is the city's position on release?
They do understand that at this point, we don't really have history that's known on the part of the defendant. However, the city does believe that defendant is a high risk flight, failing to appear, and risk of disruption to administration of justice. This involved, as the court knows, by reviewing the police report, probable cause of extensive or expensive property damage, and really
Is this real court?
the
Yes,
level
this
of
is
resistance.
just one
the
moment,
defendant had
Ms.
to be-
Tenwell. One moment.
All right, okay, if it's real court, I want to do the title.
This is real court, Ms. Nguyen. This is real court. And right now the prosecutor's talking and we're going to let her make a record. Go ahead. Thank you.
Oh, thank you. The defendant had to be tased, and drugs were found on her. So, I mean, at this point, I think it would be difficult to ascertain if.
Can I go home,
Ms.
please?
Nguyen, can you put the video back on, please?
Can I go home, please?
Can you please put the video back on the
I
iPad?
want to go home.
I understand that, but I need you to put the video back on, please.
I want to go home. And I need food and water and a plea. I get enough.
Mr. Arnatti, do you think this might be something that will resolve tomorrow?
I don't know. That's the thing, is it,
Yeah.
when I questioned about use, she said no. And so I don't have that information. So if the court wants to set it over, we can, but I know that it seems that being in custody is causing pretty significant anxiety. I did see her yesterday. I didn't talk to her yesterday, but I saw her and she was in the same exact position that I saw her today, which was just standing at the glass at the door, staring out the door. Because I went to see somebody else and I happened to notice, but I didn't realize it was the Seatac case. And then when I went back there today, she was in the exact same position. So I guess that's our, I don't have an answer for the court.
Okay. Ms. Chenweller, what are you basing your argument that she's a flight risk on? Do you have any information? Oh, thank you, Ms. Nguyen. I appreciate you turning your video back on.
I am basing that at this point on her level of resistance with law enforcement and the way she's conducting herself today, that she's not going to comply with court orders and return to court. We don't at this point really know if that has to do with drugs or mental health. That's what I'm basing it on at this point.
I have nothing, there's nothing in her record that says to me that she won't abide by court orders, and it may be that
No, and I understand that, but given the level
Yeah.
of the alleged resistance, I'd have to ask for bail, minimum 500 cash or bond, 250 on each of the two charges.
I don't know what you're
If the
and
court
you
is
don't-
gonna set conditions, I would request that those include no contact with Motel 6, and I have that address if the court needs it.
I'm hungry. Can I get some breakfast? It's like 9, 10 o'clock. I need breakfast.
okay, I'm getting out of it so you can.
No, I
Okay, great.
Ms. Nguyen, can you please listen to me for a minute?
I need food though. I can't do this when I don't have food. I don't have food. I need food. It's breakfast and I haven't had breakfast. I haven't had medical care. I haven't read my rights. I haven't had any charges. I barely have food. I have no fucking water. That's how you guys are treating me. Is it humane? And I'm bleeding. And they're
Ms.
not even looked at. Where's my medical care?
Ms.
Yeah,
Nguyen,
that's
I'm
no. I am entitled to my rights. So please give me my food, give me my rights, give me a nurse, give me my charges and stuff like that.
you've been read
Okay?
your charges.
But that I
I'm
didn't
going
even
to-
got my Miranda rights. So what's
I'm
happening?
Ma'am, I'm going to release you on your promise to appear. I'm going to release you, so you're going home today.
Yes, please.
On condition that you attend all future court appearances, have no new criminal law violations. Update your address with the court and DOL immediately if there are any changes. The address we have on file is on 51st Street in Seattle. Is that still where you can receive mail?
Can I get some food?
Can you receive mail at that address, ma'am, on 51st Street in Seattle?
Huh?
Is that your address on 51st Avenue South in Seattle?
No.
Do you have anywhere you can receive mail? Ms. Nguyen, if I wanted to send you a letter, where would I send it?
Post office. I'll pick it up.
General delivery in Seattle?
Yep.
Wait for it. It's Kim Partays again.
Hey, she said she's releasing me. Can you let me out now? No, she said she's
And no
releasing me.
contact with Motel 6 at 16500 International Boulevard.
I'm hungry. I don't have something. I can't sleep.
I'm
I
gonna,
don't have water. I'm very thirsty.
Stay out of the Red Roof Inn, lady.
I'm also ordering that you not use or possess any alcohol, non-prescribed drugs, including marijuana, or possess any drug paraphernalia.
Of course, please. Oh, I'm so hungry. Why are you guys starving me?
I'm gonna order a out of custody 1077 evaluation, speedy trials told, pending that.
She's not done.
Can I get some food? I'm hungry. I'm so thirsty. Why are you treating me like this?
Because you're a jerk.
No, seriously, talk to me. Why am I being here?
I'm gonna just set this over till May. I don't wanna, I think if she's out of custody too long, we'll release her. So I'm gonna set this for, May
Are you
5th
releasing me?
at 8:30 in the morning.
Are you releasing me?
Yes.
You cannot do this because you know why? Because I'm very depressed and sad. And it's hard to fix someone that's like that after being through a lot from their family, losing their fiance, not getting married, losing all the friends. In a place like this, yes, you get very sad. You can't fix a person like that. It's called depression. Okay? That's why I'm like this.
Okay. Well, Ms. Nguyen, we'll see you back here on May 3rd at 8:30 in the morning. You'll need to come to Seatac Municipal Court.
Come to Seatac.
Yep,
Can
I'm
I go
appointing-
out and get some water, please?
I'm appointing Ms. Dryanoti's firm to represent you, so you need to stay in contact with them
I
too.
need water and food. You guys have water and food, right? Why can't I have water? You guys put stuff in that water. I'm not drinking it. I want a bottle of water. I know you have a bottle of water. Can I have a bottle of water, please? Please. You know I deserve a bottle of water.
Ms. Nguyen, you can give the iPad back to the officer.
This room, this feels like very static to me. I can't fucking be in here. You can't fix a person like this. Please help me, help you. You don't even know why I'm here. Please give me a bottle of water.
Oh my God.
Why are you trying to control me for? No.
And Your Honor, it sounds like we are going to have a Burmese interpreter, and I think we can probably get this on, or Mr. Gone resolved. So if the court.
Okay. You wanna bring him back?
And I want him to
Yeah, I'm going to make sure the they didn't bring him. I'll go grab him though.
You are trying to deprive me of my food rights. No. You are not giving me food and water and nurse. When 702 is 832, Mr. 832. 832.
Does she have a shawl on? She definitely got tased. Definitely. Again.
Give me more water and more food. Then go get it and I'll give it to you. I'm not hurting you, am I? I'm not
Ms.
hurting.
Nguyen, Ms. Nguyen, can you give the iPad back to the officer, please?
No, I'm very thirsty. I'm about to pass out from dehydration. You're gonna give me water. I'm being starved out here. It is not
I can't do ma'am, I can't do anything about that. I'm not at SCORE.
I'm not gonna do that.
Can you please give the
You know
iPad
there's
back to
fucking-
the officer? Thank you. That was gonna be my next suggestion.
Judge Rhea Perlman with the burn. Grim, I think she ate way too many Tide Pods to begin with. No more Tide Pods for her. Yikes. All right, let's roll. Oh, man. Do we remember Mr. Lentz? I covered Mr. Lentz part 1, part 2. We have part 3 of Mr. Lentz. Remember Mr. Lentz? He talked like this. He talked like this. He wouldn't stop talking. Judge Anzalone just had enough. She goes, "That's enough, Mr. Lentz." Well, he's back, and I think he's taking a plea. Well, let's roll. Mr. Lentz. He's got some serious charges, too. Yikes. We haven't had Anzalone on in a while. Let's enjoy.
All right, so we are back on the record in the matter of people of the state of Michigan versus Kerry Michael Lentz. Ms. Underwood, have you now had a moment to speak with Mr. Lentz?
Yes, I have, Your Honor. And I've
All
spoken
right.
to him earlier this week, just to make sure we had our ducks in a row. Mr. Lentz, it's my understanding, will be pleading no contest to count 1 with the habitual offenders being dismissed.
All right, so he's going to plead no contest.
To aggravated indecent exposure, the 2-year high court misdemeanor with
Okay.
the habitual being dismissed, Your Honor.
Okay.
Please listen to what he has done on top of his original charges. Mr. Lentz is a perv.
All right, so Mr. Lentz, you want to raise your right hand for me?
You dirty bird.
Yes.
Do you? Thank you. Do you solemnly swear
Dirty pigeon.
truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Okay, and thank you for speaking up. The way they're set up, you're kind of faint. So now, Mr. Lentz, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, aggravated indecent exposure, which is a high court misdemeanor that carries a maximum penalty of up to 2 years in prison and or a $2,000 fine? So is it your intention to plead no contest to that?
Yes, ma'am. Yes, due to the reasons that, I mean, as I presented to the court, I'm not gonna gamble my life over a misdemeanor charge. I believe that's, in my own opinion, unconstitutional, that's cruel and unusual to be faced with such, in my view, a machination. But the main aspect is, on top of that, I'm not properly receiving.
So, Mr. Lentz, we can't really hear you, but I just asked if it was your intention to plead no contest. So you can just say,
What's up, Les? What's up, Heineken?
Yes.
okay, you'll get an opportunity to make a statement at the time of sentencing, okay?
Okay, it's just that's supposed to be conditioned based on the issues that I
Can you let them know, are you able to scoot up, like closer to the device?
I just want to make sure this is supposed to be conditioned based on the issues that I presented to the prosecutor and in a letter and to the court, to the letter and in my preliminary examination, just jurisdictional issues. I just want to make sure that's on the record about that.
Mr. Lentz has no idea what a period is, or an exclamation point, or any punctuation ending at all.
So none of that was presented to me at the preliminary exam because I didn't do it. So I've never received a letter from you. And I'm sorry, that's not information I have. Do you want to plead no contest or no?
Yes, yeah.
Okay, all right. And do you understand? So Mr. Sneed and Miss Underwood, there is a SORA notice. I don't think tier 1 applies. Does he have a prior conviction?
The conviction is the 2009 conviction of using the internet, Your Honor.
Okay. So that would make this, is it a tier 2 or a tier 3? For sex offender registration purposes.
I'm not sure if that was that a sex offender registering?
So there's a SORA notice attached, said if it's a tier 1, if the victim is a minor, which doesn't apply here, I don't think. And if it is a tier 2 offense, if the defendant has a prior conviction for a tier 1 offense. And if it's a tier 3 offense, if the defendant has a prior conviction for a tier 2. So I don't know what using, I don't have that information on my felony information as to whether using the internet to commit a crime is a tier 2 or tier 3, or if SORA applies at all. So Mr. Steen?
Your Honor, under the SORA statute, using a computer to commit a crime, it's under 750-145D2F, which is what his judgment of sentence in Wayne County from 2009 reflects. That in and of itself is not an offense requiring registration. However, there's one question which I had emailed counsel about yesterday, which is if the conviction for using the internet to commit a crime under that statute does become a tier 2 offense requiring registration, if the underlying offense, using the internet to commit the crime, if the underlying offense is a violation of the statute MCL 750.145C, which is child sexually abusive activity, which we don't know whether or not that is the underlying crime. There is some information indicating that that may have been the underlying crime. And so if that is the case, I wouldn't want it to later be found out that his conviction for using the internet to commit a crime is a tier 2 offense based upon the underlying crime being child sexually abusive activity.
So, and I don't have access to lien or anything, Ms. Underwood?
Here's where I'm kind of at a loss about that. My client pled guilty to using the computer to commit a crime, and we do SORA based on what they plead guilty to. So I'm.
Well, what I would say is I don't have the information because I don't get a copy of a lien or his prior history. So I think that someone needs to be able, Ms. Underwood, perhaps look at his prior offense.
We have the judgment of sentence, Your Honor. We have.
Okay, so will this offense require him to register as a sex offender?
Not the offense that he was found guilty of.
But was it a tier 2 or tier 3?
Your Honor, he was found guilty of using the internet to commit abusive activity, or he was found guilty of the statute in the amended complaint, Your Honor, under the habituals.
All right, so Mr. Lentz, your prior offense of using a computer to commit a crime, did it require you to register under SORA?
No, I've never required, I'm not registered in law enforcement information network.
Okay.
I've never been convicted as a
So,
sex offender.
Based on that information, Mr. Sneed, would I be wrong in assuming that he would not be required to register under SORA for this offense? Or he would?
I believe that stands to reason that he would not be required if he hasn't done so in the past.
All right, so Mr. Lentz, we're going to move forward, assuming that you're not going to be required to register as a sex offender. In the event that information is wrong at the time of sentencing, you can withdraw your plea and we can look at it again, all right?
Yeah, yes, ma'am.
Okay. Now, are you satisfied with Ms. Underwood and the advice that she's given you?
Regarding this specific issue, yeah, I'm satisfied with this issue.
Excellent. All right, so neither the prosecutor, the defendant, or anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Ms. Underwood?
It is, Your Honor.
And Mr. Sneed?
Yes, it is, Your Honor.
All right. And is that correct as far as you're aware, Mr. Lentz?
Dealing with what? I couldn't hear you.
So neither the prosecutor, the defendant, nor anyone else has had a conversation with me about a possible sentence with this court. Do you agree with that? As far as you know?
No, I haven't heard anything.
Okay, if a no contest plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agrees, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. Mr. Goldstein, Mr. Goldstein, I'll be taking Mr. Crystal next, so you're next. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Sir, do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would otherwise be appealable had you been convicted at trial? Do you understand that?
Not fully, but yeah, I understand generally. Yeah.
All right, so do you understand if you had gone to trial and been convicted?
What's up, Robert? What's up, Peach?
Appeal. Do you understand that?
Yeah, automatic, right? Yeah.
Yeah, but by taking a plea, you don't have an automatic right anymore, and so some of those issues would not be appealable. Do you understand that?
Yeah, appeal by leave. Yeah.
Okay. Do you understand that any appeal from the conviction and sentence pursuant to the plea would then be by application for leave to appeal and not by right? So you wouldn't have an automatic right to appeal. You'd have to file an application for appeal. Do you understand that? All right. So, Mr.
No contest.
Okay. All right. Has anyone made any threats or promises to you to induce you to plead no contest to this charge?
No.
Okay. Do you understand that if I accept this plea, you will be giving up any and all claims that your plea is given as a result of promises or threats that were not disclosed to the court on the record during this hearing, or that it was not your own choice to enter the plea? Do you understand that? No one's made you any promise?
Been subject to any direct threats. I just like to rule out any indirect threats as well.
All right. So, Mr. Lentz, nobody's made any indirect threats to you, have they?
No, the issue is just that indirectly is that I'm having my life lived and being held at jeopardy. I mean, you can say it's not direct. I haven't received anything that's saying, oh, you're going to do this, so I'm going to kill you, or say, oh, I'm going to
take good. All right. So has your attorney promised you any particular sentence or estimated what your sentence is going to be?
Okay, good.
Yeah, you said estimated? I mean,
yeah, she told you what any sentence is going to be?
She just told me what I faced. What I would face is 2 years maximum with the charge.
All right. Is it your own choice to plead no contest?
Yeah.
Okay. All right. So, Mr. Sneed or Ms. Underwood, who's going to place factual basis on the record?
Your Honor, I'm happy to do so. The defendant, inmate Gary Lentz, was lawfully imprisoned at the Gus Herron Correctional Facility, which is in Township of Madison, Lenawee County, State of Michigan. And it is true that on October 29, 2022, prisoner Gary Lentz exposed his penis while masturbating in the view of Corrections Officer Brandy Phipps. Corrections Officer Phipps was conducting rounds at the time when she observed Lentz through his cell door. The MDOC misconduct report composed by Corrections Officer Phipps stated on the date and time being October 29, 2022, while doing rounds, prisoner Lentz, inmate number 655484, was directly observed through his cell door holding a small erect penis with his left hand and moving it in an up and down motion. These actions were made in an attempt to harass or degrade the officer. At no time did prisoner Lentz have staff permission. Left hand and moving it in an up and down motion. These actions were made in an attempt to harass or degrade the officer. At no time did prisoner Lentz have staff permission to perform these actions.
All right, Miss Underwood, anything you would add to that?
Such a child.
No, Your Honor.
All right. Based on the facts placed on the record and from the information contained in the police report as cited by Mr. Steen, the court finds beyond a reasonable doubt that on or about October 29th of 2022 at the Gus Harrison facility located in Madison Township in the county of Lenawee, that the defendant did make an open or indecent exposure of his person by fondling his penis in an area of view of correction workers working there at the time. And therefore the court accepts the no contest plea. Has the court complied with MCR 6.302 B, C, and D? Mr. or Miss Underwood?
It has, Your Honor.
Mr. Sneed?
Yes, it has, Your Honor. Thank you.
I accept the plea. It has been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. This court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them. I'm going to refer this matter to the probation department for a pre-sentence investigation. Ms. Underwood, are you available May 25 for sentencing?
What date, Your Honor? I'm sorry.
May 25.
Yes, Your Honor.
All right. Mr. Lentz, where are you currently residing?
Oaks Correctional Facility.
Oaks Correctional Facility. Miss Teskey or Miss Holly, who's handling my pleas today?
I am, Your Honor.
All right. So, sir, someone will be in contact with you from the Michigan Department of Corrections to prepare a pre-sentence report. Obviously, you pled no contest, so you don't have to make any admissions to them about the events that occurred, but be truthful with them about your background, and they'll prepare that report. Ms. Underwood will receive a copy of it, and she'll attempt, and usually she's really good about it, to meet with you via Zoom or so forth to review that, and then we'll see you back on May 25 at 8:15 for sentencing. Mr. Lentz, do you have any objection to being sentenced by Zoom like we are today? You have a right to be in person.
Okay,
You know,
I'd rather prefer, I think it's more proper just in general to be in.
I can't hear you, sir. Sir, I can't hear you. Do you want to be in person or do you want to be sentenced via Zoom?
I think it's just more proper to be in person, to be important in person.
Okay, so I'll mark down that it'll be in person. So we'll see you in person that day for sentencing, all right?
Yeah, thank you, Your Honor.
Oof.
All right, thank you. You
They
have
had
a
to
good
put
day.
small in, didn't they?
Oh,
Bye.
why don't we alert?
Okay, so we're gonna go to Judge Dad. Let's get to Power Couple. He had an eventful day today. I think the best one out of today I plucked. This one is a great one. You can find it in my playlist. Let's have a good time with this one.
Yes, Judge.
Where?
Walmart,
How much do you make?
$18.50 an hour.
All right, so if you're going to have a lawyer going forward, you're gonna have to fill out a petition, okay?
Okay.
I'm gonna set a bond here. The allegation is she sold over $980, $985 worth of.
But Judge, if you want the detective to come in and speak to bond, this is there's some going on here, but if you want the detective to come in and speak to bond, he'd be happy to. He's on her side.
He's on her side.
Yes.
I didn't say anything about needing any detective.
I know,
I'm just
Judge.
I'm just telling you what the accusation is.
Yes, Judge.
I was gonna give her a personal bond. Do you want me to get
No,
the
Judge.
detective in
No,
and
Judge.
talk about the bonds?
No,
See if it's
Judge.
gonna change my mind.
No.
$1,000 personal bond.
You don't have
You're not to have any contact with Ada Thomas or any employees of the Woodhaven Speedway. You're not to enter or go near 19900 Allen Road in Woodhaven. You're not to have any contact with prosecution witnesses. You cannot leave the state without the consent of the court or violate any law. You must appear in court as directed, also as a condition of your bond. You have to go over and get fingerprinted and photographed at the Woodhaven Police Department by 2 p.m. today. We're going to give you an order down the hall. Also, if you want to fill out a petition for a court-appointed lawyer, you fill that out, and I'll be happy to look at that. Any questions?
Judge,
I work Monday through Thursday.
she was hoping to get to work by 12 p.m. today. Is it possible for her to go after work?
What time does she get?
What time do you get off
Hang on.
work?
I get up at
8 o'clock? Well, the police station is open
Hang on.
all night.
It's okay, because I do overnights too. so
Hang on.
We have 2 shifts.
Hold on.
Turn your flashlight on your phone.
I'm sorry.
She's just really
Hang on.
upset about the whole thing, Judge.
Well, I don't know what to tell you.
I know. Hold on. Judge is gonna speak to you.
You can either go right now, or if you want, I can have you leave and go at first thing in the morning.
You wanna go first thing in the morning?
It's not the problem. I can go there.
Okay, then you go now.
Okay.
No.
Go by 2 p.m. today.
No problem.
That's the court date. You're gonna go down the hall, you're gonna fill out a petition for a court appointed, you're gonna get a notice, you're gonna
What's
get
up,
your
daylight?
condition of bond sheet, you're gonna get your order for prints. We're gonna adjourn this out to the 19th, and that will be at what time?
9 o'clock.
Is there a problem?
No.
Well, tell me what the problem is. Is there a problem?
I just feel like.
You don't, listen, you don't wanna say this stuff right now, what you said to me, okay? We're gonna take care of it, don't worry. We're gonna get the discovery, okay? What time, Judge, on the 19th?
9 o'clock.
Call the prosecutor. and-
I'll get it, Judge.
So that will be the new court date, April the 19th at
Thank you.
9.
Thank you.
And then we'll address something with Mr. Urich here. Mr. Urich, your name?
Good morning again, Your Honor. May I please call William York on behalf of the city of Woodhaven.
Have you looked at this case?
We have looked at this case, Your Honor. I believe this is the matter involving.
I just want to be clear because I picked up a larceny file. It says that this young lady stole $985 worth of lottery tickets. That's all it says on the citation. I would never look at the police report unless and until there has been a conviction.
Welcome,
It's
James.
inappropriate. Ms.
Thank
Murphy has said that the detective is on her side, on the side of the defendant. The defendant here is hemming and hawing as though I'm asking her to walk backwards to Tuscaloosa when I asked her to come back. So I want to make sure that you thoroughly looked at this case.
Yes.
and that you think you can prove it beyond a reasonable doubt, because so far the vibe that I'm getting is that this is an injustice. We don't want any injustices to occur.
Your Honor, if I may, the detective's position made quite clearly to Ms. Murphy was that he would endorse the most forgiving outcome possible under the ordinance, leaving all sentencing discretion to the court. The only reason I'm aware that we were adjourning this, despite the fact that there is a confession in the record, is that Ms. Murphy requested time. Initially, she entertained a plea bargain, but then she requested time to review videotape and to see what the restitution amount might be.
All right, it's just that when I
This lawyer really is getting on my last nerve, bringing her tissues. Like, come on, give me a break. Wait until you hear what she did. Ugh, give me a break. This lawyer's awful, by the way.
might get a vibe like this, when I'm being told that a detective is on the side of the defendant, I think those were the words, the detective's on her side, that would lead me to conclude that the detective does not think the case should go forth.
And I gave you the wrong impression.
Hang on. If a detective is on the defendant's side, and the people of the state of Michigan, or in this case, the city of Woodhaven, are still proceeding with the case, a big red flag goes up, and it's an ugly one, and it tells me one of two things. It either tells me they shouldn't be proceeding with this case, or particularly since I've gotten this vibe from the defendant as though she's the most oppressed person in the history of, hang on. She's shaking her head, acting like the fact that she has to come back is some big imposition. She doesn't have to come back again. We can set it for trial if everybody wants. We don't have to set it for another pretrial. But I asked to go get prints, and now she was acting like there's no way she could get there.
No, Judge, that was me. That was me.
Why was it you then if your client didn't say that? Wait a second. Hang on. This is what I'm talking about. Advocacy is one thing. But you made a statement, Ms. Murphy, that the detective was on her side. Now, I don't know what that means, but if I'm the defense lawyer and I'm telling the judge the detective's on her side, that is the side of my client, I am going to also be thinking that this is an injustice, that the case is proceeding beyond 11:30 on April the 5th, the first date of the first pretrial. Now, he tells me detective's not on her side. Detective said he wasn't going to get involved in sentencing, which he shouldn't be. He's not the judge. He's not the lawyer. He's not the prosecutor. He's not the defendant. And I don't know how to put it anywhere closely as nicely as I just can after what I just said. So stop acting oppressed. If there is something that should be dismissed, you dismiss it. If there isn't, fine.
Your Honor,
But I don't want to hear from her acting like she can't come back here or this is some great imposition. It would be a horrible imposition if you had no case and you have to bring your case with you. You don't have a case to bring with you, dismiss it. That's what you should do. I'm getting an entirely different vibe on both sides here. You can apply for your court-appointed lawyer. Be happy to give you one. April 19th will be your your date at 9 o'clock. Presuming you qualify, Ms. Murphy will still be representing you. You're going to go to Omaha, fill out your petition, get your court date. You're going to take your condition of bond sheet. You're going to take your order for prints over to Woodhaven and get printed by 2 p.m. Thank you very much.
Your Honor.
Thank you.
And if I may, the people of the city of Woodhaven do not authorize and recommend warrants for execution by this court unless we believe we can.
I'm not suggesting that you were. It's just that I just got this feeling.
I misspoke, Your Honor. What I should have said was that the detective indicated that he wanted her to have the best possible outcome. He felt that she was put in a bad position at work.
Okay. Okay,
And that's what I should have been more clear.
good enough. You're all set, ma'am. Go down the hall. Good luck. Melissa Marie Johnson, 23W7549.
That was a goodie. Oh, that was good. So next we're gonna go to let's hit up let's go to there's no content for this at all. It's just me being a jerk. Why do you think I recorded this? Just wait for it.
Good luck to y'all. You too.
Guys, make sure you hit that like button. If you're not subscribed, go hit the subscribe button. We're over 6,000 subscribers. A little under 2 months. This will be my 100th video. Show your support for the channel. Super chats.
So we went ready on the Robinson matter?
Memberships are live.
Yes, we're ready.
Everybody's here.
Yes.
Guess why
Okay,
I
anybody in the
recorded
Robinson
this.
matter can turn on their mics. Turn on their cameras and we'll get ready to call the case.
So it looks like the host has turned off my video.
Okay. I think that's probably be fixed pretty soon here. Oh, there you are.
Arr!
Great. And my party witness is Jalen Robinson.
I can't.
Okay.
Jalen?
Just unmute
Thank
your
you,
mic and
Tupac.
turn on your. There you go. All right. All right. And I'm assuming you need a record.
Yes.
All right. Calling cause number. Were we supposed to wait for the AG on this one, or is that the other one?
They're not appearing.
Oh, they're not. Okay. Yeah. Calling cause number D1 AG 13-000-958 Robinson versus Riley. Please make your appearances for the record.
My name is Richard Shannon. I am attorney for the petitioner and the SAPSER modification.
My name is Richard Shannon, and I am a supervillain.
The half-sib of the party of the child before the court. That is
Marvin Holmes. What are we gonna do with Mr. Holmes?
Here we go. What is my favorite thing that Judge Stevens does? Here it comes, and it's a doozy of a timeout. Let's roll.
It says reviewed competency, is that what it is?
Well, Your Honor, yes.
That's been done already, hasn't it?
It has been done, and he was deemed competent. Prior to that, after I called the motion, and after I called the motion, I went to visit with Mr. Holmes, and I don't know if you recall this, you probably don't. But the last time that we appeared,
You've got a copy of this, this one that's been filed March 1st of this year?
Yes,
Okay.
sir.
All right.
He was agitated and screaming and indicated that he did not want to speak with me. I attempted to speak with him and he refuses to speak with me. So I don't know if maybe we can try that again today.
Come on out. This is Marvin Gabriel Holmes.
So I'm not sure what we're going to do until after.
Well, the expert says there's nothing that indicates a problem.
I
mentally.
understand.
No evidence of active mental illness, which could be just him
Which is,
exercising temper tantrums or attempting to manipulate the system.
yes, sir.
He is charged with
Evading the prior.
and illegal possession of
and
benzyclidine, which,
Yes.
but that's second degree.
It's enhanced, yeah.
Is he enhanced to a habitual felon?
I don't believe he's habitual yet.
This
They have
is second
received a
degree.
notice, but
07 convictions, 207, and then It says that after that, he's convicted in
He
2011.
does have priors, yes, sir.
So he is looking at 25 to life.
He is, Your Honor. I just normally receive a notice of their
All right.
intent to enhance.
Okay, you are Marvin Holmes. Yes. And Ms. Perozzo, very fine lawyer, is here representing you. We have received a competency evaluation here from Dr. Edgar Pond, who evaluated the defendant. You interrupted. You know, and here, Dr. Grapon, I have known. He was the man who evaluated the people who killed James Byrd. That's how I first met him. He is one of the nation's finest psychiatrists and evaluators of people who were charged with crimes. He has evaluated you in a report dated February 22nd, 2023. He deems that you are competent that to proceed with your case. There is no evidence of any active mental illness. So this is Court's Exhibit 1. It will be made a part of the record without objection.
No objection, Your Honor.
And state?
No objection.
Okay. So in each of these cases, we're going to take up, there's 21-37984 where you were charged with a state jail felony of evading arrest. And this is on or about May 10th, 2021. It's a state jail felony and there are prior convictions that are alleged, which means you could be convicted of this state jail felony, but I believe the punishment could be up to a second-degree felony punishment, up to 20 years in prison. Yeah, you just have to understand. In 39923, you were charged with illegal possession of phencyclidine, which is a terrible, evil thing on this planet. I wish phencyclidine would never have been found, but it is out of the box and it is an evil thing. But possession of it, illegal possession of it, is.
I'm sorry, Your Honor. Did you just threaten me? Did you just
Hey,
make
no,
a threat towards
wait,
me?
Laurie, move right over there. Mr. Holmes, just listen to me and be quiet. Do you understand? I have ordered you to be quiet and listen. You were looking at a second-degree felony, and that you interrupted me again. This means if convicted, you face up to 20 years in prison. You also have prior convictions. If all of this were found true, you were looking, if convicted, no less than 25 years up to life in prison.
With a mental teeth feeling in my mouth.
You got anything else to say?
All right, then.
You're going to get a timeout. You're in timeout just like a child until you can behave as an adult. Shame on you. You're held in contempt of court. Shame on you. Shame on you. Shame on you. Well, he's held. Yeah, I know it. Well, that's one. But the expert says the man is competent, which leads us to believe that he has learned to manipulate the system.
Yeah.
And as long as he
They just said that he was going to hit you
acts
now.
unruly and threatens you, well, there's a way to do that. We'll just have to
I just want you to be aware.
bind him up. Anyway.
The problem is it doesn't matter which attorney. It doesn't matter.
Yeah, well, I know, but
He's going to do this with every
yes,
single attorney.
I know, and that's why
to continue representing him, but he just wants to understand.
I understand.
I'm not going to.
I understand, but the system and the rules are built for people so that the rules apply, not people who can just act like a child.
That's right.
And what is a temper tantrum as a child after he's been declared competent, clearly competent, and he can't frustrate the proceedings. And if that were able to be done, then people would catch on pretty quickly of how they can manipulate the system. But anyway, what we'll do is we'll discuss this later about
Yes.
how we might handle him. But if he's going to I mean, I hate to have to bind him, but that's what I will have to do, and I'll tell him, that's what will happen. There will be, you will be muted, and
Stevens is so extreme.
you will be bound for the safety of everybody, because the experts say you're really competent, no matter what you want to do. And he's looking at life in prison, which is not something anybody likes to have to think about, but when if you want to act like if you decide acting like a child in a temper tantrum of a child, then anything can happen. So it's built to handle that, and the only way to do it is act firmly. That's what we've been trained to do. Is when people act like that, you don't let the little temper tantrum child-like behavior rule the courtroom. It's an example we have to set. People are here to act responsibly as adults, and if you don't act, then there are methods that have to be dealt with, and you just has to be made aware that it works against him, and it harms his future outcome in a case.
Yes, sir.
And it also,
I love FN's comments. Keep them coming, FN.
For this is another reason why you shouldn't use phencyclidine, because PCP makes you act extreme sometimes. So anyway, we will work on that and deal with it so that you feel safe, Lori. And
well, and I just not that I don't feel safe. It's just, I'm not going to stand there and let him threaten me and nobody be aware of it. So he just has to understand that that's unacceptable.
yeah, and again, for the record, the defendant threatened his attorney to punch his attorney, and she had done nothing except attempt to help him in a polite way. But the man is also appears to be doing whatever he can to make not only himself the center of attention, but also to frustrate the proceedings. And that is what we'll do is we'll bring him back a little later, and I'll talk to him.
She looks like it from
She looks.
Yeah.
Just when we think Judge Stevens can't get any better, he does. I don't know if you guys saw this, but we have back-to-back. Miss Yolanda has a rap sheet and a half, and then the next guy is a winner. Let's roll. How good was that last one? Yes. Timeout equals gold court clips.
Okay, are you Yolanda Martin?
Yes, sir.
Okay. Pull Miss Martin up just a second, please. Yolanda Martin here on 41301.
She has prior.
Next. 30 prior?
Oh, yeah.
Next.
Oh, boy.
That's a lot of women.
Okay.
I think.
Okay, you doing okay this morning?
Yes, sir.
Yes, ma'am. Okay.
Ma'am?
Go back a page. Theft seems to be, your favorite crime to commit. I see some aggravated assault. Go ahead before that. 26 deaths. Okay. And we have a theft here, right?
There is no restitution in this case, Judge, which is why we only offered state jail time.
Fine. Do you understand, Ms. Martin, even if you just steal a pack of gum now because of your criminal history, a pack of gum is a felony from here on. Do you understand? Yes, sir.
Yes, sir.
Okay. All right. Just have a seat right over there before we do the plea. But when the pass get up, see what you can do. We'll take the plea. She says, you don't want to defer for a few weeks, depending on, on the result of the test.
Hey, John, see, log into this.
Campos is her, is his client.
Is it?
Yes, sir.
Sure. Ashley Campos?
Yes, sir.
Yes, Judge, she's here. She's the restitution to pay next week in the state of.
She has no history, Judge, and we've agreed that if she will pay it back, we'll dismiss.
So let's just reset it to Mr. Mingle on his way.
I'm sorry.
Yeah. One, a third degree felony, didn't we? Another one, names on the docket. Texas versus Greg Allen Kramer, that's you? Yes, sir. Present with Ms. Mantalini, your attorney.
Oh boy, here we go.
The state's attorney is going to be here shortly.
It's Mr. Ham.
Jimmy Ham? Oh.
I'm sorry, which day?
Kramer.
Greg Kramer. He's one of the names on the docket.
We're working on the trial doctor for next week.
Are you?
Yes, sorry.
You're looking ahead. Looking ahead.
Yeah,
That's a good thing.
I missed that altogether. I apologize.
Is important. Earlier, Mr. Kramer, you pleaded guilty to the third degree felony of operating a motor vehicle in a public place while intoxicated, and you have 2 or more prior convictions.
Yes, sir.
DWIs, and you pleaded true to paragraph 2, alleging, looks like in February of 2021, you had 2 convictions of DWIs, and then in March of 21, in Galveston County, another conviction of a DWI. So, paragraphs 1 and 2 constitute a third degree felony, and we only went on a third degree felony, didn't we? I see there's a third paragraph of a prior conviction in 13, but in Ector County, but that was not used to enhance the punishment to a second degree.
In light of the agreement to catch.
Okay. So it's just paragraphs 1 and 2, a third degree felony, and the sentencing agreement is that whatever sentence shall not exceed a cap of 6 years in prison. So you were looking at no less than 2 nor more than 6 years confinement in prison. You can, there's nothing that under the law that prevents me from placing him on a regular probation, but deferred or unadjudicated probation is not an option in this type of offense. I think those are our options here. We know. I've looked at a pre-sentence report. Have the parties had an opportunity to review it? Are there any corrections or changes to it?
For the defense, I do have one thing.
Yeah.
On page 3, the first item listed under offense, he tells me that it does often come up whenever there's a run on his history that it's unlawful possession of a firearm by felon, but at that point in time, he was not a felon. So he's not sure why that keeps appearing next to it, but that he didn't have a felony conviction prior to that.
But hold on. Well, it's listed here, it's illegal possession of a prohibited weapon.
Yeah.
So that somehow something is not looking correct as in the data concerning the actual earlier offense, firearm related, but it's still a felony. It's just not unlawful possession of a firearm by a previous convicted felon, which would infer another felony previously exists, which I don't see.
Yes.
But other than that,
but it's a prohibited weapon that needs to get corrected in the
I've been trying to fix that.
Well, maybe the state will try to help work on that, since it's a computer system that,
because it even shows us
which is shocking because I've never known a computer system to really fail.
Yes.
Anyway, getting back to this. Okay, so the pre-sentence report is made a part of the record for all
Yes, sir.
purposes. Okay, go ahead.
I'm sorry, I spoke, I guess.
You can go.
Mr. Hammond, no objections. We're asking the judge to, the court to grant Mr. Kramer probation. He does have a job, and he works at a company where they test and clean firefighter equipment. And he does not drive, does not have a car, is that correct?
Yes.
And he understands the importance that if he did drive a car and he had probation, that he would have to have the interlock device on it. He is 40 years old. He recognizes that alcohol has been an issue, but also, even more importantly, that he's learned officially his lesson. I believe that if he's going to have any alcohol, he should not drink. And if he were granted probation, he understands he can't even have alcohol. There doesn't seem to be any other major issue that should concern the court, except for whether or not Mr. Kramer can follow the rules of probation and abstain from the use of alcohol while on probation. We would ask the court to grant him probation, and after Mr. Hammond's finished, the court may wish to speak with Mr. Kramer.
I'd like the defense to explain to me what happened under this recommendation section, the first sentence.
Yes, sir, and I did talk to him about that.
What happened there? You failed to appear to the pre-sentence officer for this whole thing?
Yeah, that's all me. That was my fault.
Was it your busy schedule, sir, that was interrupting?
I had just started a job and
This really didn't have that high importance?
It is very important. Very important.
Just started a job.
It was just, there was so much going on. I forgot. And then it's no good excuse for it. I apologize, especially for wasting time on it. But I had to go back and go into it. At the time, I didn't have a ride either. I mean, my mom, she can sometimes take off. Other than that, I didn't exactly have a set ride. And the paperwork is in her car. I forgot the date.
Why don't you have a ride?
I don't have a car. I ain't driving. I'm not trying to drive.
Well,
I'm now having.
You wrecked out your car here on this event because you were intoxicated. So, but nobody's feeling sorry for you.
I don't.
You got to figure it out. You make some mistakes, but let me ask you this: the phone. Do you have a phone?
I do now.
You were able to call the probation officer, were you, or was somebody, holding your hands?
I don't at all.
You had an appointment for the pre-sentencing, which is kind of important.
Yes, sir.
No, it's the most important thing.
It is.
Not according to the way you go at it. No, it wasn't. We didn't hear anything, son.
I apologize.
Go ahead, State of Texas, Jay.
Yeah, Judge, I'd like to impose upon the court to ask that he be tested. My nose may be mistaken, but I smell alcohol.
Did you drink alcohol today, sir?
No, sir.
Okay. We're going to drug test you here before we go for you. I'm
Look
glad
at
it's
Steven.
okay with you, but it's going to be ordered one way or the other. It was just to make sure. Could be just alcohol from cologne or something. I do want to ask you this. I'm looking at, and you were tested in your breath showed 0.19, which is over, about 2.5 times the legal limit. But what's most interesting is you fled the scene before the police could show up after you wrecked your car. Where'd you go?
I went walking down, I want to say it was Needleland. I walked all the way down to Needleland And then I started going towards Port Acres.
And then what'd you do?
I stopped and got 2 beers.
After you wrecked your car, you got 2 beers, huh?
Yes, sir.
Like these little small cans of beer? What?
32.
The 32 ounces, 64 ounces of beer after you had just wrecked your car.
Yes, sir.
Can you explain to me how that makes any sense at all?
He went and got
Well,
beers.
I'm not nervous, but I'm not.
Oh, does it help with your nerves?
It's my anxiety.
Can't.
Miss 4 pounds of beer. After you just wrecked a 4,000-pound missile.
Yes, sir.
And you find, but why do you stay at the scene?
What?
I'm sorry. When he's on a roll, there's nobody better. He just antiquated, and he used pounds. Who's ever used pounds for beer? He said you drank 4 pounds of beer. He's such a mean grandpa.
One curve.
Why didn't you stay at the scene?
Scared. I was scared.
Sir?
I was scared. Nervous.
Of what?
Well, what's the traffic?
You've already done all the damage you could really do.
Yeah.
So what were you scared of?
On jail, I believe, because I
How
didn't have a license.
did that end up working out for you later that night?
Still ended up in jail. Still ended up in jail.
Do
And now
you
I've got
find that
charged.
but hard to analyze? And I mean, was there any other option that was going to happen?
Couldn't just stay with the truck. I should have never even let.
I don't understand why you
to
think it's a safe haven to go get 64 ounces of beers and consume them after you fled the scene of an accident, scene of a crime.
Yes.
Okay. I just try to figure things out up here,
I know.
and a lot doesn't make sense, like your case. It doesn't make any sense. Okay.
Oh.
I can go ahead and argue if you'd like, Judge, or we can wait till the testing.
All right, go ahead.
All right, so Judge, you've already hit 2 of the highlights that I planned on it. Number 1 is that if we were going to place him on probation, obviously he would have taken a lot more care about making sure he interviewed properly with the probation department. Number 2 is the fact that he left the scene, and to his credit, it's not mentioned here, but he did admit to driving and drinking to the trooper that ended up interviewing him. But as the court knows, his blood test is what it was. What I think bodes well most for sentencing him to the 6 years is the fact that he was given probation in 2012 for the offense of possession of a prohibited weapon. He lasted about a year, but then that was revoked. So the system has already given him a chance at probation, and he showed that he doesn't want to follow that. Now, if one argued that that was a opportunity for him to learn his lesson, then we reflect on what his DWI said. It was 2013 when he received 4 years. He received a DWI in 2019, and again, 2 more after that. So we have a date of August 16th where he received one that was over 0.15 of 2019. Then he received another one on October 31st of 2019 where he receives 300 days jail along with an additional DWI where it was over 0.15. That was September 9th of 2020. So we have here just a history of drinking to an excess because it's over 0.15 in both of those occasions and this occasion here. And it looks to me like, although I believe in the probation and how probation can work, it's just not one that we should use our assets here. I think that what's warranted is 6 years, Judge. And again, I still have a concern that he may have either been drinking this morning or too much last night.
And I just have one additional thing, Your Honor. And we did talk about the May 21st, 08 offense that he received 5 years of deferred for. and was revoked and given 4 years TEC.
Why,
I don't have,
why was that revoked? Do you remember?
My wife at the time filed an assault charge against me, which was dismissed. But my PO was getting tired of waiting for the courts to take me to court. And so eventually she just revoked me.
These are the records I have, Judge, to that office.
I don't even need to see it. I mean, I can read. So.
the only thing that I was understanding from him was that the basis of the motion to revoke was dismissed just after the revocation went through. So that's what he explained to me. I haven't seen the records, I don't know, but that he got revoked, and then just shortly right after that was when the actual allegation that made the basis of the revocation had become dismissed.
Other than that, I was making all, like, I was doing my community service. I got my hours done quick with my PO. That was, probation was out of Ector County, but I was getting supervised in Galveston County in Santa Fe, Texas.
Okay, so your final answer that you want to stand by here is that when you were placed on probation for this unlawful possession of a firearm, you were placed on 5 years deferred or unadjudicated probation in September of 2012. And then you were revoked and sentenced to 4 years in prison in November of 2013, about a year and 14 months later. And the reason that was you were revoked and sentenced to prison was what? Because I'm having a hard time. Huh?
Assault against a family member.
Okay, so you committed assault against a family member.
She was hitting me and I put her back.
You committed you committed assault, or was she the one assaulting you? And you were a victim here, so quite naturally you got revoked for being a victim.
We were arguing and fighting. She hit me and pushed her back.
Did you get convicted of the assault or not?
I believe it was dismissed.
You don't know?
She filed multiple ones.
You don't know? It says in the pre-sentence report what happened to it.
That one was dismissed. The one that
No, it wasn't. No, you served 6 months in the jail. You were, the date of offense is 11/26/12, which would have been 2 months after you were placed on probation. And you were convicted of it and served 6 months in the county jail on September of 2014. And you want to stand there and look at me and say it was dismissed?
No, I know there was one assault that was dismissed. Remember, I was locked up.
Oh, you've got so many of these, you've got confusion in your mind?
No, it was just with this one woman. Checking record, there is no assault against anybody else outside there. You just like.
I can trust your word again on this? The same one?
Yeah, just.
All right.
Or just.
All right. Let's see. This was a prohibited weapon.
Short barrel firearm, short barrel shotgun. Excuse me.
But I think, and I don't know because I don't have access to all the records, but what I'm understanding him to say is the revocation that occurred in 2013 was for a family assault that was dismissed, although in 14 in Galveston County, and that was Ector County, in 14 he had a family assault. Now, whether it's the same one or not, I don't know.
Page 2 of the pre-sentence report.
Look at the
page 2.
Over here.
Under 11/26/12.
Yes, sir.
Assault causing bodily injury, family member, Galveston County. Look to the next column, 9/15/14, he was dispositioned, 6 months jail. That happens 2 months after he's placed on probation. He is revoked. His probation is revoked. It's only logical to assume he was revoked because of that.
I guess I'm just.
And I'm looking at the motion to revoke probation here that was filed, and it includes that he committed on number one, on or about November 26, 2012, which is what we're talking about. Okay. 2 months after he's placed on probation, he commits an offense against the laws of Texas, namely assault family violence.
And that was the one that was disposed of in 14.
Yes, ma'am. Oh, finally. I don't have an order on that one, though. All that is a motion. Okay. All right. Anything else? What are you doing now?
You mean working?
Yes, sir.
Between an expected firefighter getting like the jackets, respirators.
That's
Stuff like that.
how much you make an hour then?
That one,
Sir?
9 right now.
Okay. What are you asking for, Stan?
6 years, Judge.
And
Probation, Your Honor.
you can follow up here. Anything else you want to add?
Just that, it appears that he is trying to do the things that would be required of him on probation. He has secured a job. And I know the court wants to go ahead and test him, make sure he's not under the influence of any alcohol. And we would ask, I would ask that the court grant him, in the event that test results in the way that I'm sure he's saying that it should, we would ask the court to grant probation.
He's not mumbling. He seems coherent to me. I don't smell anything. You ready to proceed?
Which way? So.
Are you ready to proceed? He's ready to rule. Yes, sir.
Yes, sir.
All right. If nothing further, then I'm going to find you have pleaded guilty here voluntarily. You were meant to this third-degree felony, paragraphs 1 and 2, operating a motor vehicle in a public place while intoxicated. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted in the guilty plea hearing to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt. I'm following this agreement, and you were hereby sentenced to confinement in the Institutional Division of the Texas Department of Criminal Justice to serve a term of 5 years. And you have been
All right, don't know what happened with that clip. But before it slips, let's go to Simpson.
Recall what the speed limit was?
The speed limit there is 70, but it's snowy. You can.
Look at Simpson's face. Done.
Not drive 70, so 20, less than 20 was the most manageable. And I have been doing that. I was driving since Kalamazoo. I came from Kalamazoo.
Okay. And you said that you hit black ice and you had to avoid, you went around these spin outs to avoid hitting them?
Yes.
Okay. Did you have any other options, sir?
No, the only other option is I have is either I run over those people and kill them, which is not the best thing, or the other option is I have to take my truck to a shoulder in the medium or somewhere else, so that I can avoid more casualty, so that I can take the risk myself.
Fair to say you made a split-second decision to avoid them?
Yes.
Okay. And at the time, that was the only thing you could do, correct?
That's the only option I had.
Okay. And how long have you been driving a truck for?
I've been driving since 2020, so this will be my second year.
Okay. Based on your 1+ years experience of driving a truck, do you feel that you were traveling too fast for the conditions?
No, I was not.
No further questions, Your Honor.
Cross-examination.
No, Your Honor.
All right. Sir, what happened to the other two vehicles that you say spun out in front of you?
They spun out and they left.
They left?
Yeah, they left. They left. They came
So
over
how
to me.
close were you to? So how close were you to these vehicles?
I was about. I said about 200 feet.
Say again.
About 200 feet.
You were 200
Like
feet
200
when you
two-
saw
I said-
when you saw
I-
them spin out.
Yes,
So
about 200.
if
200
I
feet
do my
around there.
calculations, hold on. If I do my calculations correctly, you're telling me from 200 feet, you could not bring your rig to a complete stop in the roadway if necessary?
Yes, there was a black ice everywhere.
Hold it. But you weren't steering on the black ice, were you?
Repeat again.
You weren't steering on the black ice. You said you had to take your vehicle to the shoulder because of these cars spinning out in front of you.
Yes.
You're 200 feet away.
No,
right?
about 100, I said about 150. I said about 150.
Oh, so now you're 100 feet.
150.
How close were you to the vehicle spinning out?
So the way we were trained is we always
No. Answer my question. Because you're
Yes.
giving me three different answers. Are you 200 feet, 100 feet? How close are you to those vehicles spinning out?
I said about 150.
100 feet.
Your Honor,
150.
he's
Yes.
saying 150.
About
Oh, he's
150.
saying 150
I'm the captain now.
feet? Okay, so you couldn't bring your rig to a, sir, you couldn't bring your rig to a stop in 150 feet going 20 miles an hour.
Yes, but there's a black ice. That's the issue, and I hold the brake.
All right, I have no further questions. Any further questions based upon the testimony of the defendant from the court's questioning?
No, Your Honor.
No, Your Honor.
All right, thank you. Any other witnesses for the defense?
No, Your Honor.
Closing arguments.
Your Honor, I would just rely on the testimony.
All right. Sir, closing argument.
Hold on, sir, please. Your Honor, what you have is, you heard the testimony from two individuals today, one that was present and one that wasn't. The officer testified that he responded to a unknown vehicle crash. He said that he saw the semi-truck crashed into the barrier. He specifically indicated that, the weather was bad that night. There was multiple spinouts. He said that he did not specifically see Mr. Muhammad driving. He didn't know how fast he was going, but he also issued him a ticket for a violation of basic speed law, driving too fast. I mean, he didn't personally witness Mr. Muhammad driving whatsoever. Now, you did hear Mr. Muhammad testify that he was driving. The conditions were poor that night because of the ice and snow. With that being said, there was a spin out in front of him. He said that based on his year plus of driving a semi-truck, he was always told to go around to avoid. In his own testimony, that was that if he would have continued and tried stopping without going around on the shoulder, then he would have ultimately, in his opinion, killed those people. He was going less than 20 miles per hour in the snowy conditions. He was the one that told you how fast he was driving. I don't think, based on the fact that 20 miles an hour is way under the speed limit, that it would be driving too fast for the conditions. What he did was, at the time, because he hit black ice, is he had to make a split-second decision, and that decision was to avoid hitting the cars that spun out in front of him and potentially killing someone. So he went around, and when he went around on the median, he ultimately hit the barrier. With that being said, Your Honor, I do not think that he should be found responsible for violating the basic speed law based on his own admission that he was driving 20 miles per hour or less, and especially when you have an officer that didn't even witness him driving whatsoever. With that being said, Your Honor, I'd ask you to find him not responsible.
Trooper arrives at a single crash, single act vehicle crash. the defendant or the respondent's testimony is inconsistent. He's first saying that there's black ice. He is also, upon direct questioning, indicating that he was able to maneuver his vehicle to the side, and that's what caused the damage. Quite frankly, it's going to be one or the other. I don't believe he was doing 20. And if he was doing 20, he should have been able to bring his rig to a full stop within that distance prior to those other vehicles spinning out. Plus, all those other vehicles spinning out, of course, oddly, they're not even around at the time that the trooper does arrive at the accident. The respondent's testimony, quite frankly, makes no sense. The basic premise of the violation of basic speed law is that the driver is responsible for the conditions that are there. They cannot operate their vehicle any faster than those conditions would allow. Clearly, under these circumstances, with him having to do what he did, it'd be one thing if he slid off the road on black ice, but he maneuvered his vehicle off of the road, trying to go around them. If he had to do it in that fashion, he was driving too fast for the conditions. And so therefore, for those reasons, the court would find that the defendant is responsible. Fines and costs of $130 are to be paid. I don't know if he posted a bond or not. When can he pay it?
Your Honor, can I add one thing?
Sir, when can he pay the $130? Sir? When can he pay the $130? Within a week? Mr. Muhammad?
Yes.
Can you pay it within a week?
I don't have money right now.
Okay. The court wants to know when you can pay it.
I will try to borrow from my friends.
When can he pay it?
Sir, can you give the court a definitive date when you can pay the $130?
Can I have a month?
$130. When can you pay it?
Can
He
I
said
have
30
1 month?
days, Your Honor.
Can I have 30 days?
Pay it by April, well, pay it by May 1st.
Thank you, Judge.
Thank you. Court calls the case, People versus Justin Kerry.
Caitlin Kirby on behalf of people.
Good morning, Your Honor. Robert Mullen on behalf of the defendant. Your Honor, I have received a discovery in this matter. I didn't know that who the prosecutor was. I know we're not going to be able to pre-try today, but I'd like to talk to her about it. There's some interesting issues in the discovery that I think weren't a discussion.
All right, so
before there's a
let's
final settlement.
rock and roll
If
to
not,
last time I checked, if you don't like somebody's content, get the fudge out. Go start your own channel, do what you need to do, and we'll come and follow you. Bye. All right, let's roll to our new girl, Judge Coleman. Thank you, Tommy V, for calling it out. We got somebody. This is a goodie, I promise. Turn the volume up all the way on this one. You don't want to miss a second of this one.
Spoke with them, and they have Bear. Heather, oh, Mr. Carpenter, did you speak with Mr. Ball?
Now, if you guys don't know, she's in the same court as Judge Dad. So, Judge Coleman and Hessen in the same courthouse as Judge Dad. Fun fact.
Baldwin yet? Your lawyer?
No, I haven't spoke with anyone yet.
Okay, he's meeting with somebody else right now, so I'm gonna put you into breakout room 3, Mr. Carpenter, and he'll meet you there shortly. Breakout room 3.
Oh.
And Ms. Bear, this is the case of Heather Bear. 17W810745, your name, please.
Heather Buer.
I'm sorry, pronounce your name again?
Heather Buer.
Buer, thank you, Ms. Buer. You do have the right to have a lawyer represent you. If you cannot afford your own attorney, I will appoint an attorney to represent you. Would you like to speak with the lawyer before we begin, Ms. Buer?
Yes, please.
I'm going to put you into a breakout room. Mr. Baldwin is the lawyer here today. Mr. Crawford, you're ready on yours? Okay, it'll be just a moment. I'm going to put you into a breakout room. Mr. Baldwin is finishing with one client, has another just before you, and I'm putting you into breakout room 5. He will be with you shortly.
Okay, thank you very much.
You're welcome. So we just have to let Mr. Baldwin know he's in. I would make him a co-host. But he's in 4, he has 1 waiting in 3, and then after that, 5. And then I need the case for Mr. Crawford, but I don't have the file. And I need it from Denise, please. Okay.
I missed 2 court dates, big deal, I wasn't feeling.
Sounds like it's really raining out.
And all they are is Jay walking on the street with there's ice on the side.
Sorry, Hart.
That was all.
You're a faithful.
No walking on.
Thank you, Allison B. Thank you, everybody.
These are the cases of Gregory Sorrell, 23W831113.
Mr. Sorrell.
23W831317. Your appearance, please.
Good afternoon, Your Honor. Michael Crawford, representing. Well, Your Honor, the defendant made it abundantly clear that he did not desire, wish my services in this matter. So I don't know how fair it is to say that I'm representing him, but I have offered my services, and seems to be a desire to represent himself.
Thank you. Mr. Sorrell, state your name for the record, please.
Gregory Lynn Sorrell.
Thank you, sir. Understand you have the constitutional right to have a lawyer represent you. And if you cannot afford your own attorney, I have a lawyer here ready to represent you. Would you like to represent yourself today for purposes of the arraignment? Or would you like to speak with a lawyer?
No, yes, because I want to speak. Last time they tried to take my gun from me and give me a year probation, and I took care of it myself. I don't need a court-appointed lawyer.
Okay, and on behalf of the city of Woodhaven, your appearance, please.
Good afternoon, Your Honor. Please for William, you're appearing with and on behalf of the city of Woodhaven.
Thank you. And detective, your appearance.
Detective Ryan Bear, Woodhaven Police Department.
Thank you. Okay. These are Judge McNally's cases.
Walking on the street, I got one for walking
Name
on the
dropping.
street. Simple.
Mr. Sorrell, sir, just
knows we're
hold on a
watching.
moment. I have one and Judge McNally has one. Okay. All right. So there are allegations here that you trespassed in the city of Woodhaven on March 2nd, 2023. And were a disorderly person on April 4th of 2023, also in the city of Woodhaven. These are both charged as misdemeanors, both punishable by up to 90 days in jail, up to $500 in fines plus costs. In addition to the right to remain silent, you also have, in the right to have counsel, you also hold the presumption of innocence. You have the right to have a trial. You have the right to have witnesses called to testify on your behalf. You have the right to confront any witnesses who will be called to testify against you.
I want a trial. I want a trial.
Mr. Sorrell, hold on a moment, sir. So for purposes of the arraignment, I've entered a not guilty plea on your behalf. I've entered a not guilty plea on your behalf. I'm going to order you to undergo a competency evaluation.
I've already did that. I've had it done already.
I
Well, then why are you
understand.
doing it again? Why are you doing it again?
Well, these are new charges out of a different community. My understanding is you just underwent a competency evaluation. And Mr. Sorrell, sir, you were deemed incompetent with no likely chance of regaining competency. So those 6 cases out of Brownstown.
By your psychiatrist. Huh?
No, not mine, sir, not mine.
You were so crazy. Well, then I'll just have whatever I want anyway, illegally. So, all right, go ahead.
So, Mr. Sorrell, listen carefully, sir. That psychiatrist, that psychiatrist who evaluated you is not someone that works for the court.
He's full of shit.
That individual is an independent individual and made a determination that you were not competent to stand trial. That's why those 6 cases were dismissed.
You wanted to give me that. Okay, I'm ready for whatever. Go. I want to be released.
That's why those 6 cases were dismissed out of Brownstown. The prosecutor made that determination that she was going to dismiss those cases. Those were for trespassing cases. And then there was a destruction of property case there at the Secretary of State. Those cases are dismissed.
Oh, man.
Now this is a new trespassing charge out of March of 23, and April 4th of 23 is the disorderly person. The allegation for that charge is that you were allegedly inside a location and engaged in indecent and obscene conduct in a public place with children present.
Where?
And that you used obscenity in front of customers toward a police officer.
Oh, man. My phone was in there and I went to get them phones and that's all I did to trespass. Oh. All right.
So again, I've entered a not guilty plea on your behalf. And Mr. Urich or Detective Barrick or both, would you like to speak to bond or bond conditions?
Your Honor, I would defer to Detective Barrick first, and then if I may speak last if necessary.
Detective Barrick, would you like to speak to bond or bond conditions?
Only that the city of Woodhaven has responded at least 7 to 10 times in the last week or two in reference to Mr. Sorrell with
called her an asshole.
Either being trespassed.
I'm going to Point Mouillet. As soon as you release me, I'm going to fish and go to Point Mouillet. I ain't coming back here.
It's an ongoing problem.
It won't be. I'm not coming back. I said I'm not coming back, Your Honor. I'm going to Point Mouillet and I'm going to catch the biggest fish I've ever caught on Wildlife Refuge. You know, I'm an outstanding citizen. I am, and all this crap over walking on a sidewalk, a ticket for there was ice on the sidewalk, and they're slanted from the Mexicans making them. That's why I went onto the road.
Okay, Mr. Sorrell, I've entered a not guilty plea. I wanted to, you stated that you were homeless, sir.
I'm headed back homeless. I love it. I'm going out to the woods. I can live in the wilderness. Yeah.
Okay, thank you.
Yeah.
And Mr. Urich.
Your Honor, the city takes absolutely no pleasure in offering these remarks for the court's consideration, but Mr. Sorrell has created multiple difficult situations for citizens and businesses going back to
I think this is going to resolve. Judge, could
most
we?
Recently, these were circumstances wherein he was basically lodging at the laundromat on our information and belief, and trespassed from that location multiple times and refused to leave. And then we had the incident in the nail salon, and despite the best efforts of the officers to de-escalate, obviously the episode took place as indicated in the warrant. We believe
have
that
a docket conference. This is going to resolve it. I do need to see this.
He has no plan
Would
for
you like
health
for
care.
the offer to remain available?
Thank you. And other occasions, we believe he's
healthcare right by law.
That the court consider a substantial cash bond in this matter. With those appropriate conditions should he gain his liberty. Thank you, Judge.
Thank you. And Mr. Crawford, I know that Mr. Sorrell is choosing not to use your services today, but I would like to give you an opportunity to speak with respect to bond or bond conditions.
Well, Your Honor, it is my I would surmise from my limited interaction with my client that he would desire a personal bond, but beyond that, I would leave it to the discretion of the court.
Thank you.
I need personal bond. I need to get out of here.
Mr. Sorrell, anything else that you would like to offer, sir?
No, ma'am, I just know that I have insurance. I can show you. I got the best insurance. You don't know what he's talking about. I'll show you my wallet. You don't know what he's talking about. I'll show you the wallet and the insurance. And I'm going right to Point Laurier, and I'm not coming back for a while. I have to come back sometime, to get my stuff out of my mom's house, Trenton, the rest of my valuables. I can't wait. And I am getting a job. I can get a job at the Hilton if I wanted. I've drove 6 million miles. I can get a drive at the Hilton. I don't know what they're talking about. I could. Parking cars.
I'm going to set you for a pretrial on April 12th. April 12th at 9 a.m. I just believe that I need to order a competency evaluation now. So the April 12th date isn't going to hold. Heather, I'm going to need a date for Woodhaven docket, and it's going to be about 8 weeks from now, depending upon the timing. I don't know if they're going to, they just conducted a competency evaluation for Brownstown within the last few months. And just probably 3 weeks ago, Mr. Sorrell's cases were dismissed with the findings. So there was competency hearing stipulation that he was not likely to regain competency. And then
Let me show you how competent I am. You want to know math? You want to know what? How competent I am? Yeah, I am.
So I am going to order a competency evaluation.
And everything else, skills. Go ahead. Go ahead.
And Heather, I need a date, please.
7 weeks, we have Woodhaven on May 24th, and then 9 weeks, we have them on June 7th.
Photogenic mind.
We'll do the June 7th. At what time?
We're open, so what time do you prefer, Judge?
June 7th, Judge McNally's put at, it's in person, June 7th, we'll put Judge McNally's at 9 o'clock and mine at 9:30.
Okay.
Yeah.
Judge McNally, the bond for the disorderly person is $20,000, 10%, Mr. Sorrell, $20,000, 10% on Judge McNally's disorderly person charge. And
personal bond. Personal bond.
And on the trespassing charge will be 7,500, 10% on mine.
Personal bond. You're sending me where then? Huh? Where are you sending me to? County again? Huh?
I have no control over where you will be sent. I don't make a determination on where you're housed.
You're making a big mistake. You send me to county again.
So you will get the information on your competency evaluation.
Who gives a fuck?
And then I will.
I better not go to jail right now. That's all I got to say.
9:30 on June 7th in person is your pretrial. Those are your bonds.
What?
These are your bond
June
conditions.
7th? June 7th? That's a long time. What do you mean June 7th, huh? June 7th?
You have to undergo a competency evaluation, sir.
That don't take till June 7th.
It does.
See, you're fucking railroading me. You know what you're doing? You're railroading me, man.
No, Mr. Sorrell, and watch your use of profanity, sir.
I'm gonna miss
So I'm gonna
all
go over
this
your bond
business.
conditions with you. Mr. Sorrell, if you don't stop talking loudly over me, I'm gonna have to mute the microphone, sir.
What are you gonna do to me? You're already sending me to jail. Right?
Mr. Sorrell, I'm gonna mute your microphone if you don't stop talking over me. You cannot leave the state without first seeking consent from this court. You cannot violate any law or ordinance. You must appear at all future court dates as directed. No contact with any prosecution witnesses, including but not limited to Jason Clifford, the Super Suds any of the Super Suds employees.
Stay out of the Super Suds.
Hold on one moment.
That was great.
Shall not return to or re-enter the premises of 22470 Allen Road in Woodhaven, Super Suds. No assaultive, abusive, intimidating, or harassing behavior toward anyone. When I say no contact with any of the prosecution witnesses on any of the cases, I mean you cannot confront, write, phone, text, email, use any other mode or means of communication to try to contact these individuals, and you cannot direct anyone else on their behalf to do so.
I'm going to activate a phone right now, finally, down, put money in my bank.
Also, you shall not return to or re-enter the premises of Venus Nail and Spa located at 22124.
Why is that? I had to finish a nail appointment. Why is that? Okay, no problem. I'll do it myself like a normal. I will go get my sandwich though down here. They stole my sandwich, the cops, and ate it. I will go get that.
Mr. Sorrell, you can have no contact with any of the employees of the Venus Nail Nail and Spa.
I'm going to the place next door. I'm getting my sandwich that the cop ate. And I paid for it. Your cops.
Cop ate a sandwich.
You cannot possess or have access to any firearms or weapons. You are required to be fingerprinted and processed at the Woodhaven Police Department if that procedure already hasn't taken place.
It's happened 10 times.
And a GPS tether is going to be ordered, and you are not to return to the limits, city limits.
What do I need a tether for?
The city limits of Woodhaven.
Oh, man.
You're out of your minds, man. A tether for what?
The cop stole a sandwich.
I've never, ever.
All right.
Had a tether. I'm not standing
Any
citizen
questions?
before.
No, Your Honor.
None, Your Honor.
All right, Mr. Sorrell, you're all set, sir. You're going to be given the information you need on where to attend your competency evaluation, and then you will be here in June. Well, that's not nice. Don't stick your tongue out at me, Mr. Sorrell.
I'm sick of it, man. You know what? I'm an outstanding citizen. I did nothing wrong. I
haven't said that you weren't, but I'm not going to have you stick your tongue out at me, and I'm not going to have you use vulgarities toward me. Mr. Sorrell, you're all set for today. You're going to be transported where the city of Woodhaven is going to have you held, probably at county, I'm not sure. And then you'll get the information you need on your competency evaluation.
Fuck you, who cares? Fuck you, who cares?
Mr. Sorrell, calm yourself down, sir. You're all set, Detective Barrett. Thank you.
You're sending me to county, I'll do what I want. See, you're just sending me to county again for what? I witnessed for Jesus, man. That's what I'm about, to witness for Jesus, and you're sending me to county.
Mr. Sorrell, you're all set for today.
You found Jesus.
Thank you.
Bravo, Hessen. Bravo. All right, so we have some new people. We got 322, so I'm going to bring back Mr. Wharton from last night because we had such a screwy the stream last night. Everything was going out on me. I just don't think we caught the essence of how good that video clip was.
No comments, sir.
Whoa.
No comments. Different
Where
case.
did that come from?
Sir, just keep your voice down, please, because we're on the record, okay?
What's going on?
I did hear you, and I'm asking you to please keep your voice down. We're on the record.
Judge Stepmom's going crazy. Bravo. Okay. Let's bring back Mr. Wharton. Guys, just listen to this phone call. You're going to love it. I'm going to get a headache after it, but it's worth it.
And the city is moving to dismiss without prejudice on that case. Again, this is one ending in 4726, based on some doubts as to whether the city could prove that case beyond a reasonable doubt.
Any objection from the defense?
No objections, Your Honor.
That be dismissed without prejudice. And then on the other two.
Your Honor, we have a motion to continue to May the 2nd. Your Honor, Mr. Wharton is adamant that he was in custody on those
2 violation dates as well. He believes that the court, as well as Mr. Mercer, is aware of that. We're just requesting a short set over to May 2nd so that we can obtain the documentation to show that.
Any objection from the city?
No, and my memory is just that it was the discussion about that one on February 16th. But all that would be recorded. Mr. Wharton could go on to the court's website and listen to the audio and hear for himself what was discussed. But I believe he was present on video last time, actually, instead of
And that's my recollection as well, that the only case that we discussed at the last hearing was the case ending in 726, not the case that was ending in 755 or 754.
Understood, Your Honor.
Mr. Wharton, do you understand that you're waiving your right to a speedy trial in order to get this continuance, and you'll need to unmute by hitting *6?
Your Honor.
Hi.
Your Honor, you remember me, right? I was
I
gonna go
remember.
to the Union Gospel Mission.
Yeah.
Remember,
I have a lot of
was
people
gonna
at
go
the
to the Union Gospel Mission.
There are a lot of people who come to court.
So we
what
need to have a
happened was,
discussion about this, Mr. Wharton.
Mr. Wharton, we're not discussing the case today. Today is not a fact-finding hearing. It's just your attorney's making a motion to continue.
So that we can get the documentation.
Right. I'm trying to move to Arizona right now, and I just don't want to have anything hanging over me up in Washington State.
Okay, well, one of the things that's hanging over you in Washington State is you have a warrant out of 10th Municipal Court.
I know that.
Okay, you'll need to clear that warrant before the next hearing. So, sir, do you understand that you're waiving your right to a speedy trial in order to get this continuance?
Yes, this is a really difficult case for me because, I didn't commit these crimes and I was in custody when they both happened.
And it looks like your attorney's going to look into that. That is not the issue today, okay?
Mm-hmm.
I don't have the information in front of me and the prosecutor doesn't have the information. So the prosecutor doesn't sound like it's making a motion to dismiss today.
I'm going to go down to the King County Courthouse because last time I was there talking to the lady down there, she verified that I was in custody until January 19th.
And Mr. Wharton, you can keep telling me all these things. It's not going to make any difference today. I'd like to focus on the fact that you're asking for a continuance.
Okay.
Okay, so you understand that you're waiving your right to a speedy trial in order to get this continuance?
Yes, ma'am.
And is that what you want to do today?
Yes.
I'll
I'd
grant
like
the
to get this whole thing resolved today.
I understand that. It doesn't sound like that's possible today.
Well, last time we went through this, ma'am, it took less than 3 minutes to pull it up on the computer screen and show that I was in custody.
I'm not the one who's making a motion to dismiss. It's the city, and it doesn't sound like they're satisfied and they're not willing to do that today.
Mm-hmm. Right. Well, how many guys have a goatee and a baseball hat running around Seatac Airport? That's what he went off with. That's what the arresting officer went off with.
Mail at the address. I don't have any address for you at all. Where do you see?
No, I don't. I don't.
He's homeless at the moment, Your Honor.
Okay.
I thought he was living at the Union Gospel Mission.
Yeah, that didn't work out very well.
It was supposed to be long-term inpatient, is what I remember. So,
it didn't work out very well. I went in there, stayed for a little bit, and then.
I didn't mean to open the conversation, but that was.
Mr. Wharton, don't get into it.
Okay. All right, Mr. Wharton, thank you. We'll see you back here on May 2nd at 10 o'clock in the morning.
Thank you.
Oh, everybody, it's been great. Thank you for coming out. Thank you for listening. Thank you for taking care of the channel. I will see you tomorrow. You've been served. Good night, people.